Item number 1, pronouncement of judgment.
So we have, yes, this judgment. We have considered the case of both the parties, submission and contention of the parties, and also the impugned judgment. I'll read out only the operative portion. On an overall consideration of the facts and circumstances of the case of the appellant vis-a-vis the impugned judgment and sentence, this court finds that the said judgment and sentence have been rendered on firm legal foundation. The same is hereby upheld. Consequently, this appeal is found to be devoid of merits and is hereby rejected.
Publish.
Any mention? Item number 2.
May it please. State has filed the status report number. There were 3 issues, which your lordship has been examined.
One second. Unscannable extraction. Okay, yes, but Advocate General.
Yes, lordship, there are 3 issues your lordship has been examined. Kindly come to page number 2, my lord.
This is the report filed on 30th of May.
28 and 29. 30th report.
30th of May.
30th of May. Report was filed 30th.
Yes.
Yes.
And your lordship, kindly come to page 2, my lord.
Yes.
Lordship would recall that 192,840 tons of coal was found by Garuda outside the designated coal depot.
Yes.
And there was observation by Justice Kataki in this regard. For that purpose, our explanation is in Annexure 1. If your lordship may kindly come to Annexure 1 at page 50.
Yes.
With reference to the subject cited as per the minutes of the meeting relating to PIN number so and so,
Yes.
held on 5th November 2024 and 25th March 2025, and to inform you that as per the physical verification of coal stock of year 2019, a total of 16,31,633 metric ton of coal was found in East India district. However, as per the Garuda Zone Survey conducted in year 2020, only 10,487.502 metric ton of coal was found, which was shifted to CIS depot as per comprehensive plan and auction procedure. In the meanwhile, multiple petitions have been received by this office from individual coal stock owners regarding their coal stock being present in 2019 physical verification report and missing from Garuda UAV survey 2022 with request for reassessment and permission to transport their stock to CIS depot referred to 5th November 2024 included Annexure 1. Whereas a new Garuda survey was conducted in year 2025, where an additional 180,299.48 metric ton is found to be available outside CIS depot. As paragraph 2.2 of the minutes of meeting held on 25th March 2025, Annexure 2, the chairman of single member committee has directed the undersigned to verify whether coal found outside CIL depot by Messrs. Gaura UV Software Limited is same coal as claimed by petitioner, and if so, the same cannot be seized, and in fact same may be transported to CIL designated depot as per comprehensive plan and procedure. Otherwise, coal shall be seized and appropriate action under MMDR Act shall be undertaken. As per direction number, the undersigned has directed Divisional Mining Officer Joy to verify the same. The process of it is still ongoing, as there are about 1,572 coordinates dumped with area covered under 233 square kilometer in the new survey report, which are to be physically inspected for verification. As on date, based on the joint inspection carried out by Executive Magistrate and Divisional Mining Officer, total 9,012 metric ton was found to be outside the designated depot and not belonging to previous stock owners has been seized and shifted to CIL depot. For 11 other locations, only amount of 9,000 has been found. 9 metric ton has been found. During the same verification, against the report of 45.83 metric ton in Garuda report at point 2 of the meeting held on 15th May in Goji report. As regards the undersigned, would like to submit that as additional 1,80,290 metric ton found in East India district as per new Garuda UV report might include the stock of coal owners which have been included in physical verification report of 2019 and was missing in Garuda report of 22. However, final status with respect to ownership and quantity of coal available outside CLU can be certain after physical verification of 1,572 coordinate dump with area of 230 square kilometer in Garuda. So, the under office of undersigned has also given a public notice bearing anyone to ship any coal outside CLU. Verification is complete, my lord. And pursuant to this, my lord, if you lordship will see page 17. Page 17 is the report of first the complaint which we have received.
Is it all complaints?
No, this is the minutes of the meeting of the Justice Kataki, my lord. And if you lordship will see page, this is 5th November 2024, paragraph page 17 and middle of the page, my lord. Regarding representation filed by C. Data and 22 others, claiming that their coal stock has not been included in the drone survey report by Garuda UV Limited regarding petition submitted by coal owners East India. Secretary Mining and Jewelry informed the chairman, single member committee that joint inspection report from the Divisional Mining Officer and Assistant Commissioner East India has been received. As per report, the concerned officer could visit only 6 to 8 locations since coordinates are in remote area and take 4 to 5 hours to reach. However, during the visit in these 6 to 8 locations, coal was found to be available as claimed by the complainant. Divisional Mining Officer then requested committee to conduct aerial drone survey for remaining coordinates which are in fast-run area. Chairman then instructed Secretary Mining and Jewelry Department to engage conduct aerial survey for remaining coordinates. A status report on the proposed to be taken and action may be filed by 12th November. And then thereafter, you lordship will see at page 18. It is a meeting on held on by the single member committee at 25th March 2025. Page 18.
Yes.
Regarding aerial survey to be conducted for areas outside coal limited and designated depot in coal producing district. Chairman single member committee informed the members present that discussion on the subject has been held in the meeting on 24th March 2025. However, he reminded all duty commissioners concerned that the report of Mrs. Garuda solution has been forwarded by Mining and Jewelry Department and action to seize the coal may be undertaken in terms of provision of MMDR Act since the coal found outside the CIL is termed as illegal coal and necessary court order may be obtained for auction of seized coal. Deputy Commissioner East India informed the chairman that some of the coal owners whose name and coordinates are included in authorized coal submitted before the Honorable Supreme Court in 2000 had submitted a petition to the chairman in the year 2024 as their names are missing in the aerial survey conducted by Mr. Garuda UV Solution in 2020 for volumetric assessment of inventorized coal. Chairman then suggested that the coordinates of the inventorized coal are available and report of Mrs. Garuda soft solution private limited is also available. Same may be cross-verified to find out whether coal found outside the CIL designated depot by Garuda UV soft solution is same coal as claimed to the petitioner for the quantity indicated by them, and if so, same cannot be seized. And in fact, same may be transported to CIL designated depot as per comprehensive plan and after procedure may be. Otherwise, said coal also be seized and appropriate action under MMDR also be taken. Chairman single member committee also advised the Commissioner concerned to be more proactive to increase patrolling in the far-flung areas where illegal mining is vulnerable, and in coordination with police department who are using the drone technology for detection of illegal mining of so and so. No, so, Milord,
Yes. What can we make of this?
Milord, thereafter, Milord,
Yes.
page 20 annexure 4, Milord, is the representation by the coal owners who are saying that their coal was part of inventorized coal, page 20, Milord.
Okay,
And,
okay, yes, okay, we are okay with that. Now, what about the other? Now, we'll look at the 13th interim report also. See, this is the representation by these people. Sitting here, we can't really, as far as committee, they can, after this, what has been
Yes,
done?
Milord. Now we are inventorizing and we are checking the coal coordinates and we are checking the coal on the physical grounds, Milord. And wherever we find that it is outside coal coordinates, we are seizing and we
You're
have
seizing
seized
it?
about 9,000. Yes, Milord, because in coal coordinates, if it is found, the coordinates which have been filed in the Supreme Court, Milord, in terms of Supreme Court, those coal have to be transported to the coal depot. But if it is outside the coal coordinate, if your lordship will see, we have seized about 9,000 metric ton under the MMDR Act, and we are auctioning it and we are filed FIR and processing in accordance with section 21 of. So we are doing it and we are reporting to the
Now, you're
committee
saying
on
there's
daily basis.
1.8 lakhs. Okay, you can see 1.8 lakhs, which is found outside the CIL. Now, you admit all these figures can be reconciled. You mean with the owners who say that is their coal outside, although it was inventorized but not entered into the report.
Drone survey.
The only thing is how do you explain 1.8? That's all.
Now, the Milord, what has happened, if you also will see, there are 1572 coordinates. In 1572 coordinates, they say that these coordinates were part of 2019 Supreme Court report, Milord. The Garuda UAV carried out survey in 2022 and in terms of their survey, it did not figure. Thereafter, a representation was submitted by these owners saying that Garuda UAV has missed it. Now, and then the representation was given when we checked, we started physical verification because it was a UAV.
Now, you mean to say that if inventorized coal was there, Garuda missed out the coordinates and they reported this as coal outside CIL depot. That is what you're trying to say, correct? And now you're trying to reconcile that this coal is already inventorized, so it will not be subject to seizure. It'll have to be again re-verified and sent to the CIL depot.
Milord, two processes will take place. Milord, if it is not, they have the owners have given the coordinates, and the coordinates are there. If the coal is not at coordinates, then we treat it as an illegal coal and we seize it. For example, if your lordship will come to page 16, Milord, page 16 of my report.
That is what we just have to understand.
Yes, page 16 at the top, page 16 of the page 15 bottom, Milord, and page 16 below, Milord. As per direction above, the undersigned has directed
Now,
DMR.
see, we've seen that.
Yes, Milord, and then 16, Milord, 16. As on date, based on the joint inspection carried out by Executive Magistrate and Divisional Magistrate, total now 9,012.0712 metric of coal was found outside the designated area.
And not claimed by anyone.
Yes, Milord. So no, they claim and they have been seized and they have been shifted to CIL depot. For example, if you also will say, further 11 other locations, only 9 metric ton has been found during field verification as against 45 point Garuda has indicated on the basis of that approximate volume is 45. But on field verification it was found only 9. So what the government, the executive magistrate and the DC is doing, they are checking, they are going to all 1572 coordinates as indicated in Garuda, and they are marking whether it is part of the location or not, and this is separate in 233 kilometers. Small dumps are there. So somewhere we have 10 metric tons, somewhere we have got 45 metric tons. So we are, wherever we find outside, so this is a huge among the exercise which is being carried out, and we are keeping Justice Kataki updated on this exercise, and we are calling the direction of Justice Kataki on this matter, my lord. That is what I wanted to say on this
Okay.
point, my lord. The second point, my lordship,
Yes.
if your lordship will see my report once again at page 2, point A, I have placed the information before your lordship. The second point is, so far as we have taken page 9, that there was some confusion with regard to interpretation of survey data, my lord.
No, that has been updated in the other report
That
that
has-
I've seen, yes.
yes.
That has been corrected because it was not there before the committee when the interim report was filed at that point of time.
Correct.
That's all right, yes. What about
page 9 only, bottom part, my lord. Third point was, my lord, that there were challans in which the mobile numbers, there were 2 challans which the Justice Kataki indicated, and 2 challans there was mobile number and etc. was not there, my lord. That you lordship will see at page 9 bottom. That it is respectfully submitted that mineral transport challan were being issued by the Directorate of Mineral in Form A appended to Meghalaya Mineral Prevention of Illegal Mining, Storage and Transportation Rules framed under section 23C and which had no provision providing phone number of drivers and owners of the vehicle. That in line with the revised comprehensive amended 2022 and suggestions of the committee, additional information of details of owners and driver of vehicle will be included in mineral transport challan. The necessary data in this regard has been issued to have been directed.
what about the basic thing regarding the truck MTC being issued in, to be in a different truck number, different truck numbers carrying it? You take action against the
What
owner.
will happen if you also will kindly see the challan? What happened? There was, if you also will see that challan at page, that challan is at page 28, Milord. Page 28 is the challan, the under the rules, Milord. This challan was under the statutory challan, Milord, in which is one name, address, detail of permit, name of mineral, quantity, vehicle registration number, place of dispatch, route, etc. The issue was, Milord, that there was no mobile number address.
No, not that, not only that, General. The thing is that this mineral transport challan was issued under number 5 to a different vehicle. As it is covered from another vehicle which is carrying the coal. That we cannot reconcile. That you have to take action.
If you lordship order paragraph, previous order paragraph 7,
Yes, you can read it. Yes.
28 April,
Yes.
28 April, where your lordship has indicated 28 April 2025 order.
Yes.
Paragraph 7.
Yes.
Paragraph 7. The third aspect which needs urgent attention is the issuance of mineral transport challan issued by Director of Mineral Resources, where in 2 instances it has been found that issuance of same is violation to 10C of revised comprehensive plan, as the name and address of the owner and driver of vehicle number and also mobile number has not been mentioned. Apart from that, vehicle were checked where carrying mineral.
This is what, yes.
Carrying mineral transport challan issued under different number of different vehicles.
So fine. That you can amend. You can amend your MTC to include the.
And we have done it,
Yes.
we have, that is what we wanted to show. We have amended it, and only in out of all cases, my lord, we have only in 2 cases, my lord. Only so then we have page 29. If you lordship will see page 29, we have amended it. Page 29 of my report. We have amended that part, so we have corrected it, my lord. So wherever we find some lapse or some issue, my lord, we have corrected and Justice Kataki sees the matter on regular basis, my lord. Now there is one more report which is filed this time by Coal India, my lord. And there was a court issue without regarding reconciliation, my lord. That issue is also because of computational error that issue has arisen, my lord, and that has also been
Where's that report?
No error. So that is also there, my lord. Coal India has filed a report, my lord, on which your lordship may need to pass some order because we are also facing same problem.
Where is that?
That is Coal India's report, your lordship, is 29th May of the report, my lord.
It's an affidavit, my lord. It's an affidavit.
Who the agree with?
Coal India, my lord.
And Your Lordship, kindly come to paragraph 5 at page 3.
Oh, only 3,470 by auction.
Yes,
But it's more than that.
as per these 7 occasions they
Are you
have
sure
done.
this is a correct figure, Mr. Ahmed?
That is correct.
Latest.
Latest.
That means you could auction only 3,470 metric tons.
Only.
Last on 74 only. 74 2007.
It was on 17/4/25.
That means so it's not proving efficacious, this arrangement with regard to having a central coal depot and auctioning from there. What about, this has all been auctioned and lifted how much?
Lifted, this is the only amount removed, 3,470.
No, this is removed because some instances where the coal has been auctioned and it's not been lifted and they're paying demurrage charges, or in the event after a certain period they...
Paragraph 6 it is clear. Your Lordship, paragraph 6.
Yes, yes.
Is there in paragraph 6?
कुछ exactly कबूल वाली
Paragraph 6 the audit of
over the
entire
period that polite है
Yes.
unlimited several months and even more in designated depot, and for the purpose lifting of such coal several extensions have been granted.
But now you have a system in place, you don't lift it a certain period, it's forfeited, correct, entire coal.
Yes, Lord, but only what I wanted, my Lord, from this court, Lord, that everything is taking place pursuant to order of your Lordship and the order of the Supreme Court. If they are not lifting the coal, my Lord, what your Lordship may direct that your Lordship may do it, your Lordship may say that that if this coal is not lifted, we will see it, my Lord, because
So, Mr. Ahmed, you given suggestions here
Yes.
as to what to do with the coal unlifted.
120 days time we had suggested. If they don't
And
lift
20
it,
days
yes. If they don't lift it, then
forfeited.
they'll forfeit.
yes, my Lord, we also agree, my Lord, that this should be implemented, and your Lordship may pass the order.
This only to, but this deals only with the coal that has been auctioned. What we are more worried is about if the lakhs of coal still lying, no one bids
We
for
have to
it, and
protect
it's
it, my
just
Lord. In depot, coal depot, we have to protect it. We have no option, my Lord. The state has to
overturn coal damage
do
is
that.
overturn coal damage
We have to protect it.
environmental pollution
And because of market situation also, my Lord, your Lordship is aware that we are facing this problem. In some of the cases, money has also been deposited. So your Lordship may take judicial note of the matter
yes.
and pass appropriate order in this.
যদি রিসেল করতে বিচাৰে নিউ পারচেজ এটা কম্প্রেহেনসিভ within 120 days.
What is this file as affidavit?
This is filed on 29th
Yes.
May.
This is by Coal India.
It starts from page.
Yes. Okay, yes. Please continue. We will was already know about this. Yes.
Yes, sir. And any other report has come, Your Honor, because we are not aware of chapter 29 report.
What about the integrated check gates?
So we have taken steps, my lord, land acquisition, etc. My lord, that part is not there, my lord, but it is continuing with this the previous issue. My lord, we filed better affidavit on that. That is not there, my lord. I'm sorry, my lord, that aspect missed my attention also.
So interpretation of MBDA settle issuance of, so that's been corrected. Only done with the new one. Yes. Anything to add, Mr. Ahmed?
Lordship, page number 9.
Anything to add? What difficulties you're having with regard to the
Resale ko to cover page number 922 ase. Page number 922 ase. Resale to the cover. Yes, sir. Page number.
Yes.
We have also suggested in case of resale, the new
Case of?
resale,
Resale by the bidder.
Yes.
By the successful bidder.
the successful bidders must lift the coal under the revised terms. That is, they have to lift it within 120 days.
Resale, I mean, after they forfeited the coal,
Yes.
it's remaining like that. Okay, but I saw one part you said just I was just going to ask just now regarding the original bidder and signing agreement with new bidder. How will that work?
Once it stands forfeited,
No. Suppose he can't lift it. He has, he's successful in the bid. He can't lift it, and somewhere I'm not mistaken. I saw they said they can enter into agreement with another prospective buyer to take the coal.
no.
Yes, that was
So that can't be permitted. Yes.
that was the issue because they have saying that they want to sell the coal at a designated coal.
Page 9.
Yes.
So in comprehensive plan, Lord, this was the issue whether transport challan can be issued to the new buyer or not.
Exactly.
Because under the sale of goods act, it can be done, Lord, because if there is a proper valid sale, Lord, by A to B, Lord,
So that means
and-
what I was trying to say. Suppose now Mr. A, he is successful bidder of a certain amount, quantity X,
Yes.
right? Now he has not lifted it, but he wants to. He's got a buyer for it. Now can the DMR now issue a MTC to a new buyer?
We have to
How would it work then? But then how does sale work then? Does he have to file a registered agreement of sale or sale papers with the DMR to verify
Yes, written argument, it's there. At
Page 9.
page 9 you will see.
Yes, you
You
can.
have 3. There are cases or instances where requests have been received from successful bidders for resale of a settled lot to another purchaser. This process can be allowed subject to the successful bidder entering into a written agreement with a new purchaser.
Oh, that's well and good. But how are we going to facilitate this? Written agreement between A and B is fine, but how to make it, a binding or a concrete, a foolproof kind of arrangement? Otherwise, now MTCs can be issued to anybody. You say that he takes the transfer challan from that CIL and he transports illegal coal from somewhere else. How will he check that? It has to be consequent. There has to be consequent lifting of the coal and transportation. But that has to be looked again, Mr. Advocate General. You kindly yes. Otherwise,
we'll come out with a comprehensive, foolproof mechanism.
you can't have such a simple, arrangement that sale agreement you give and then like necessary documentation be given to the new buyer.
They'll have to comply with, the new buyer will have to comply with all the terms
That we have
as
suggested.
per the new plan
New comprehensive plan.
that we have stated.
Otherwise confiscated.
In the event of violation, it will be confiscated.
One more worrying is that you see only 3470 metric tons have been sold.
That is the last,
Entire from the
that last occasion.
That is on last occasion.
Perhaps the quality has gone down,
What is the market in Bangladesh also? That's why.
and market also must have affected.
Okay. Take down. A status report on behalf of the respondent, State of Meghalaya, to the 28th, right? To the 28th. 20th interim report, correct?
Yes,
20th
yes,
interim
my lord.
report
Yes, my lord.
of the Honorable Mr. Justice Retired B.P. Kotoki Committee has been filed. And the three major areas of concern, which is reflected in the order dated 28/4/2025, has also been addressed by the state respondents. Firstly, with the coal amounting to 192,840 tons outside the CIL designated depots, including 180,000 tons, 299.48 tons in East Giant Hills. B. Interpretation of aerial survey maps by the Meghalaya Basin Development Agency (MBDA) in certain villages of Southwest Khasi Hills. And 3. Issuance of mining transfer challenge (MTC) by the Directorate of Mineral Resources, stated to be in violation of Clause 10 (C) of the Revised Comprehensive Plan 2022. Stop. It has been stated in the report that the it's before you appear for the committee and made this clarification, correct?
Yes, my lord.
Yes.
That is there, my lord.
An interim to address this, an interim action report had been submitted by the Deputy Commissioner East Giant Hills, dated 24/5/2025, which is as Annexure 1 to the status report. Which states that the Deputy Commissioner had received various complaints, representations from coal owners that their coal, which was part of the previous physical verification process, had been left out from the Garuda UAV survey, and that these persons had requested for physical verification of the same along with its geo coordinates and for transportation the same to the designated depots. It is noted that this fact also noted in the minutes of the meeting of the committee dated 5/11/2024. As per the status report, the committee in the minutes of a meeting held on 25/3/2025 has granted permission to the Deputy Commissioner East Giant Hill District to conduct verification and to take action accordingly. It is also further added report that the 1.80 to 99.4 metric tons of coal lying outside the CIL designated depot in East Giant Hills district is spread over 1272 locations and is being physically verified, and only the coal which is verified to be part of the original stock, which was verified in the year 2019, shall be allowed to be shifted to the designated coal depots for disposal by way of auction through CIL, and the rest of the coal which is unaccounted shall be seized and action taken under the provisions of MDR Act. This is what he's saying with regard to other coal, correct? Yes. With regard to other districts, it is reported that in West Khasi Hills district, and in respect of with regard to 11,707.99 metric tons of coal lying outside the CIL designated depots, the Deputy Commissioner has taken action and FIR has been filed, and the coal amounting to 11,330.05 metric tons has been seized as per the provisions of MMDR 97. Stop. In Southwest Khasi Hills district, approximately 597.65 metric ton of coal reported lying outside the CIL depot has been directed to be seized. And in South Gaur Hills district, where 35.01 metric tons of undocumented coal has been detected, the Deputy Commissioner, the concerned Deputy has directed the officials to act against the said illegal dumping. Stop. On the next, what is that? On the next point regarding interpretation of aerial survey maps by MBDA, it is noteworthy to refer herein to the 29th interim report of the committee, which has recorded that at the time of submission of the 28th interim report dated 24/4/2025, a factual incorrectness had crept in, wherein it had been stated that the Meghalaya Basin Development Agency had not interpreted the UAV survey maps prepared of the coal found in 6 villages. The committee in the correct fact placed before it has reported that the correct factual information has been received and the same is recorded in the said 28th interim report. So, in view of this development, the observations made in para 3 capital B, as well as the recommendations made in para 4 Roman 3 likely 3 of the 28th interim report dated 24/4/25 shall stand withdrawn. Stop. Reverting back to the status report, what you have to see about this resolution report at point number 3 thereof. Where's Alfred Journal disappeared? What do you say with regard to that integrated check gate?
If I could understand what the AG has submitted was, he has paid for some time so that we can look into the issue and therefore might not come up with a better.
Oh, in this report.
My lord, the check, with regard to integrated check-in,
Yes, where is that?
we have not actually, my lord, stated with regard to the check-in, my lord, issue.
Well, it's not here at all. At all.
No, no.
I don't know. When did you take your report? Okay. Indicate city. Yes. Where is it? He's conveniently shut himself out. With regard to the third aspect, that is setting up of integrated smart check gates in Bagli, Borsara and Cheragaon, it has it is seen that the situation remains the same, and as submitted by the Adelaide Attorney General, land is still being sought from private landowners to set up the same stop. And any other thing like that. It's also stated in the report that in line with the revised comprehensive plan, which is amended in 2022, additional information of details of the owner and driver of the vehicle will be included in the mineral transport challenge. And on other issues, also with regard to the point of amendment of the revised comprehensive plan 2022, when a committee suggested a time limit of 120 days, 120 days should be fixed for successful bidders to complete the whole process of deposit of full bid amount and the entire pool, failing which earnest money / deposit value should be forfeited and the pool re-auctioned. Clarification has also been given as to how 16,38,592.18 metric tons of coal has been put up to auction against 14,10,864.49 metric tons of inventoried coal, where it is explained that the inflated amount was because of inclusion of unsold coal or previous auctions. And is a computational error. Next paragraph. What's that? Next paragraph. The attention of this court has been attention. Coal India Limited, when affidavit dated 29/5/2025, has drawn the attention of the court to a very startling aspect where it has been stated in para 5 and 6 thereof as follows. Stop. Next paragraph. For perusal of para 5 above, it is indeed alarming that though the option of reassess stroke re-verified inventoried coal was done on 7 occasions, only 3470 metric MT coal has been sold, and 2,10,004.99 MT of coal remains unsold. The same, the committee is requested to examine this aspect and to suggest other methods which may be more efficacious and reliable to ensure the auction of substantial amount of the coal which is still lying in the CIL designated depots. Stop. Next. Next paragraph. A 30th interim report has also been filed, which address 30th interim report has been submitted by single member committee and is based and updated information on the basis of updated information derived from the meeting held on 13/5/2025, which discussed the various issues in the present PIL. The information received from the state government, that is on the setting up integrated smart check gates in Bagli, Borsora and Cheragaon. Action taken on the quantity of illegally mined coal other than reassess and re-verified inventoried coal. And coal which has already been seized has also been received. Apart from suggesting that action be taken against the it's please switch off the phone, please. Very disconcerting. With regard to the process of taking action in respect of the quantity of one 96,800.70 metric tons found in aerial surveys conducted by MS Garuda and MBDA. The action in respect of aforementioned entire quantity of the mine coal needs to be taken as recommended urgently, as is the possibility of pilferage and transportation of such illegally mined coal from coordinates mentioned in above mentioned aerial surface spots. The details of the respect of information relating to action taken by state government as furnished has also been summarized in a tabular form. The report has also suggested the action needed to be taken against the owner driver of the vehicle registration number ML10A4862 with regard to several infractions which have been recorded in the report. Next paragraph. The report has also furnished the information gathered with regard to a news report published in the Highland Post relating to the death of a labourer in a mine shaft in Musiang village in East Jharkhand district. And it's been observed that as the veracity of the news could not be established by the police authorities, as there has been no information or official report of such an incident, it may be that the same may not at all be reported to police station, and such laborer may have not been taken to any medical facilities available, as it may expose the continued illegal mining activities, if any. Stop. The committee, in its report, also the view that a detailed inquiry needs to be conducted by an officer not below the rank of inspector of police to find the truth or otherwise of the news report, and to submit the same submit a report to the Superintendent of Police. The Superintendent of Police also required to oversee such an inquiry and submit a report to Managing Authority Department as well as the committee within the shortest possible time, preferably a fortnight. The report is also, next paragraph, noted the representation of Giant Hills Cement Manufacturers Association for exemption of standard operating procedure, which has since been rejected. Stop. Another important aspect is the audit of source of coal utilized by coke oven plants, ferro-alloy plants, and captive power plants and cement companies, where it's reported that the said audit is still going on. Which is yet to reach logical conclusion. It is recommended that the appropriate authority and state government needs to take a final decision on the engagement of institutions for verification of the claims of cement companies. Stop. Other areas. I would regard to the shifting of seized coal to such depot. The extension granted to successful auction purchases. The revision of SOP 2024. Which is yet to be notified by the state government. Okay. Stop. Next paragraph. Apart from other heads such as clarifications which are still necessary, extension of time, as other heads such as status implementation of the program for alternative livelihood and status of closure of existing coal mines, and other proposals pending before the oversight committee. A very pertinent issue has been raised, which the committee feels is required to be considered by the oversight committee, by the oversight committee. This is regard to the proposal which has been forwarded to member secretary in pursuance to the order dated 13/3/2025 passed by this court for amendment of the revised comprehensive plan of 2022 in the matter of forfeiture of entire bid amount. This is what you're saying, Mr. Aman. Bid amount deposited in the event of failure of the successful auction purchaser to deposit the entire bid value, or to lift the auction purchase goal within time limit, as well as to put up the call for the auction, which as observed above, the said proposal is still pending consideration. Stop. This issue, the above noted issue, has also been flagged by the Coal India Limited in its affidavit dated 29/5/2025. Stop. Next paragraph. In view of this detailed interim report, the affidavit of the Coal India, this court notes that with regard to the setting up integrated check gates, at Bagli, Borsar and Charagon, immediate steps have to be taken for acquisition of land on rent or on lease. Stop. Appropriate action under the provisions of MMDR Act in respect of the entire quantity of 1,96,800.7 metric tons should be taken immediately, preferably within a period of 1 month. Stop. Next. Appropriate action against the owner as observed earlier, and also to ensure that no vehicle carries coal beyond the permissible load capacity of the vehicle. The state authorities also to ensure effective surveillance of all vulnerable areas by the existing drones as well as by regular police patrolling. Reactivate and strengthen the district level monitoring committee, the district. For compliance of clause 8(j) of the revised comprehensive plan 2022, as per recommendations of the committee in its 28 interim report. take all required steps for realization of existing demurrage charge and also imposition of further demurrage charges. To notify amended clause 9 of the SOP 2024 transportation of coal and other minerals from outside the state of Meghalaya. To provide information sought for by the Member Secretary MSPCB so that necessary action in term of an order dated 25/11/2024 passed in writ petition civil number 720/2023 bracket Druk Fuels Limited DRUK FUELs Limited versus State of Meghalaya and others by the Honorable Supreme Court be taken urgently. To ensure conduct of detailed inquiry to allegation of death labourer in a mine shaft Musyang village. To ensure conduct of inquiry, take necessary action as per law on the basis of finding to ensure, and there is a point for me, to ensure conduct of inquiry of involvement of persons named by R with regard to illegal activities. And also for necessary directions to the offset committee constituted by the NGT to take final decisions on proposals pending. Stop. Next paragraph. The 30th interim report noted the 30th interim report is very exhaustive. Is noted very exhaustive and dealt with the entire gamut. Very exhaustive. Copy of the same. Not very exhaustive. The court notes the detail mentioned in the court notes and appreciates the details which have been laid out in the 30th interim report of the Justice PP Contempt Committee. Stop there. A copy of the report be made over to state respondents with a direction that a detailed status report be filed on the aspects as discussed above. Preferably within 4 weeks. 4 weeks from today. Next paragraph. Further remuneration of some rupees 3.5 lakhs including other amounts for secretarial expenses, etc., shall be paid to the Honorable Mr. Justice, retired BP Kotoki. Yes. Oh, last, before other states report, before exhaustive, before para, before that. Are the directions? Huh?
Take any action the involvement of person may and the illegal activities and also the necessary interaction of the oversight committee constituted by the MDT and to take a final decision.
To take final decision of proposals. Assembly, yes. Now let's stop. The affidavit filed by the Coal India Limited on the offence, the states also required to file a report on this to respond to the same before the next date. Yes. Next on the list on. Yes. Date. You take the date, you fix the date, yes. This on June, 4 weeks, after 4 weeks, yes. Is it July? Yeah. This on 15 July. 15 July?
Item number 3.
15 July. Yes.
Lordships, the respondent number 14 was required to file an affidavit as per the last order. We are yet to receive the affidavit, Lordship.
Yes, Mr. Bhama, where is the recent developments?
My Lordship, the Deputy Commissioner of South Garo Hills has been on leave from the last 1 week, and there are some certain documents which are required to be taken from him. So he'll be joining his office this week. So maybe 2 weeks of time may be given so that I can collect those documents from there and may file my affidavit.
Yes, as prayed, Mr. Bhama, due to the unavailability of the documents, 2 weeks further times allowed. List after 2 weeks. Yes.
Obliged. Item 4 is tagged together, Lordship. Item 4 is tagged together.
Yes.
Item 4 may be fixed on 15 July, same day.
Both the matters may come up
Yes, on same day then, 15.
Obliged.
Much obliged.
Item number 1, announcement of judgment.
I'll just read this last paragraph. Last one. The legality of the impugned order has been deemed necessary, whereas court deliberated and the merits of the case discussed. It's also to discern as to whether exceptional circumstances such as breach of the principle of natural justice or lack of jurisdiction exists, or that there is patent illegality present in the face of the impugned order itself that would render statutory alternative remedy nugatory or futile. But as per its discussions, observations made as judgment, none exist. As such, impugned order will surely be amenable to an appeal under Section 111 SC Act 2003. In the totality of circumstances, therefore, the impugned order dated 23/24 cannot be held to be illegal without jurisdiction, and it petitions have recourse alternate efficacious remedy. No case made up to warrant interference under Article 226. Yes.
Item number 2.
Yeah. I see they follow.
Yes.
Yes. The main ground challenge these bills. The main ground challenge is that these bills have been raised during the pendency of WPC number 339 before this court, wherein the jurisdiction of Meghalaya has been so and so. However, with WC 339 having since been disposed of by this court, nothing stands for consideration.
Did we mention?
Any mention?
Please, Lordship. I beg to mention item 71 in Lordship. I'm praying for 2 weeks'
71?
time, Lordship. Yes, Lordship.
What's this matter about?
Your Lordship, this matter pertains to denial of pensionary benefits as per the old pension scheme.
No objection, my lord.
Yes,
Obliged,
please,
Lordship.
yes. Yes, please.
Please, Your Lordship. Item number 58. Yes. Your Lordship had directed that notice be issued on us.
Yes.
I don't think it will be appropriate to appear for us right now. It's Southeastern Coalfields, part of Coal India, but we deal with only notice and coalfields. Let notice go, Your Lordship.
We will take it when it comes, yes. I think you.
But in that case, we'll take notice.
Special step. Yes. Right.
Interim order must pass the dates of continuity.
We'll pass orders, yes.
May it please your lordship, I beg to mention an unlisted matter for tomorrow, your lordship. There's some urgency. The petitioner herein is a student at a law college and he's in his final semester. He's been debarred to appear for his exam, which is going to be held on the 11th of this month under unreasonable grounds.
What
why, your
grounds
lordship,
have been denied?
uh,
Attendance.
attendance, your lordship.
Then never went to classes.
No, your lordship, actually here the petitioner, he's suffering from TB, tuberculosis. Certificates and everything has accordingly been provided, but the same was denied. Highly obliged, your lordship.
May I speak, Lordship?
Yes, Mr. Kumar.
My lord, I'd like to mention item number 60 and 61, my lord. The marriage pending for the export, my lord. So this matter may be taken up 4 weeks, my lord.
Even after 6 weeks, yes. Yes, 6 weeks.
Please, Lordship. I beg to mention item 72, Lordship. Last item on the list.
Yes.
Lordship, I pray for it to be taken up next week.
No objection.
Dr. Musika is not here.
No, your lordship.
Let it come up next week, Lordship.
Why next week?
There is some urgency. It's
Then do it today
we are ready, but in
or
the
day after tomorrow.
Lordship, no
Why are you
issues.
mentioning?
Like, it may be next week also. Friday, anytime.
Okay, after 1 week, yes.
1 week. Obliged.
May it please your lordship, I beg to mention item number 68.
68. I don't think you need to mention it. Where's Mr. Paul? Mr. Paul, his structure is correct.
Well,
68.
Well, it's only limited extent, Ballots, that if I can seek my remedy elsewhere.
Yes.
It's infructuous because they have supplied.
Yes. It's already.
My challenge would remain, Ballots, to the terms of the tender. To that extent.
Then, yes, 68. Mr. Kepo, London Senior Counsel submits that as the contract has since been executed, the petition may be allowed to pursue civil remedies as admissible, as permissible, sorry. Or calling this matter stands closed and disposed of.
With the liberty.
With liberty given to the petitioner to seek alternate civil remedy.
I'll oblige.
Yes.
Maybe, Your Lordship, I'd like to mention item number 63.
Yes.
The arguing counsel is indisposed, Your Lordship. Can you have this matter for 2 weeks?
Who, Mr. Pasantio?
Mr. Nongdi, Your Lordship.
What's the matter about?
Promotion.
Promotion, Your Lordship.
Okay, 2 weeks, yes.
Similar pray for item 69.
69?
Yes, Your Lordship.
Who's there, 69?
Lordship. I'm there, Lordship.
Your objection?
No objection.
Yes, as this arguing counsel be indisposed, this is 2 weeks, yes.
Right, Your Lordship.
Your Lordship, I beg to mention item number 64. I pray for 2 week time. Lordship, I'm appearing for UGC.
Yeah, objection?
No, Lordship.
Yes.
And item number 66 too.
Lordship, no objection.
What's this matter about? Nehu?
Yes, Lordship. Both are Nehu matters.
Yes, okay. Yes, 2 weeks.
Obliged, Lordship.
Item number 3.
May please, Milad. Milad, here what had happened is, Milad, an FIR was filed by me against the private respondents on 17/3/2025, resulting in, Milad, the registration of Fulbari PS case number 9 of 2025 under section 117(2), 35, 351(2) and section 3(5) of the BNS, Milad. Show me.
What are these? These are equivalent 145, 144, 145?
No, Milad.
What's 117?
I'll just place.
I'm totally at CU, these new sections.
Even we are having a equally difficult time. 117, Milad. 117 is, Milad, seizure and attachment of property. Then 351. No, I think I'm sorry, Milad. IPC. I'm sorry, Milad.
There's been assault or something.
Milad, I'm sorry, Milad. They've given me the BNSS rather than the BNS.
BNS, yes, BNS.
I'll just place this. Please give me the provision. So, Malaj, what thereafter happened is,
yeah,
it would deal with assault, Malaj, because the allegation is of assault.
One
117
is 117 of this new section. Okay, 117 is.
Malaj, I'll just place. 117 is Malaj, abetment to the commission of the offence. 351 will be the predicate offence, Manoj. Assault. 351 is assault, Manoj. And section 35. I don't know how 35 comes into play. That's 35. Section 3, subsection 5.
Criminal intimidation.
Well, ballots, it is.
506.
Ballots.
Parameter base.
So what had happened is, after this FIR was filed,
yes,
no arrests were made by the police. It is still under investigation. Till that extent, it is okay. On 21/4/2025, my lords, these very accused persons who against whom I had filed an FIR barged into my house. And my lords, they again threatened me and there was an altercation between both the parties. So my lords, I again went back to the police to file a second FIR in connection with this incident. My only grievance is, my lords, the police is neither registering, they're not accepting the complaint, my lords, in the first place.
Where's your first FIR?
My lords, the first FIR is at Annexure 1, page 27.
You were assaulted also?
My lords.
Fracture also?
Yes, my lords. My medical reports are all there, my lords. At page 30, if my lords kindly have a look, my lords.
Yes, I will issue orders, yes.
Yes.
Mr. Karmi, yes, Mr. K.
Courtesy respondents.
Senior counsel assisted by so-and-so. Issue notice, Mr. H. Karmi is present, except notice on behalf of respondents 1
to 4.
1, 2, and 4. Stop. The complaint of the petitioner is that in spite of lodging 2 FIRs in connection with assault and criminal intimidation indulged in by the respondents number.
Well, it will be from 5 till 10.
5 to 10. No actions were taken by the officer in charge, Kulbari Police Station. Stop. Next para Mr. K. Polner Council. The council has drawn attention to this court to the first annexure dated. This annexure, first one is dated?
Well, the first FIR is dated the 17th of March 2025.
Wherein the case is registered.
First FIR case is registered,
the case is registered under relevant sections of the BNS, that is 117 and
351.
351. Stop. He submits that in spite of in support of the thereafter, as nothing was none of that thereafter, the five respondents on 21/4/2025.
On 20th, my lords, 21st I filed the FIR.
Entered the house of the petitioner and assaulted him, again resulting in other injuries. Stop. This incident is also reported by FIR dated 21/4/2025. It is submitted that in spite of the finding of 2 FIRs, no measures have been taken by the respondent number. Fulbari is respondent number.
OC Fulbari would be 4.
By respondent number
4 minutes.
He prays that necessary directions be issued in this regard. Next paragraph. Mr. H. Karmi Leonard, Senior Government Advocate.
Additional.
It's a please went out to obtain instructions and to file status before this court with regard to investigation or further action that the respondents 3 and 4 obtained in this regard have taken his just after 1 week.
No, 2 weeks. 2 weeks.
1 week, yes.
1 week, well, that's because this incident,
yes,
with loss of lives also.
You give 10 days, it'll be more definite. Just after 10 days for furnishing of status report. Petition take steps on the other remaining respondents and meanwhile.
Item number 4.
May I please, Your Lordship?
Yes.
Lord, the petitioner before Your Lordship is the managing committee of
Fresh matter.
Fresh matter, my Lord. Actually, it's on the earlier occasion the private respondent has challenged the order. I'll go to the facts of the case, my Lord.
Yes.
We have a limited prayer here, my Lord, is just to direct the state respondent to dispose of my application seeking ex post facto approval to proceed with the inquiry of a delinquent teacher, my Lord, teaching in the school. And the brief fact of the case, my Lord, is that there were teachers who were absent from duties. The disciplinary authority has issued notice earlier on the first occasion regarding this delinquent teacher. He has replied to show cause. Second show cause notice was issued. Then he has approached this honorable court. This honorable court has directed them to file a written statement. Thereafter, my Lord, on learning that the teacher, even though has been appointed by the managing committee, but salary has been paid by the state government. So in order to avoid any future difficulties, my Lord, the managing committee decided to seek ex post facto approval from the respondent number 3. And an application has been sent to them on 21/3/2025. but till date, my lord, they have not acted on the application, neither they have disposed of the application.
Where's the letter?
It's at Annexure 8, page 31, my lord. But interestingly, my lord, instead of disposing of this letter, the Office of Respondent number 3, by WhatsApp message, has sent one notice that is dated 15 May 2025, informing the school that the managing committee of the school will have to be reconstituted on 31st/7/2025, thereby raising a serious. That is at Annexure 9, page 42, my lord.
What connection does it have?
So we have strong presumption, my lord, that they are trying to delay this matter, and someone is trying to protect the delinquent teacher, my lord.
When's it expiring?
31/7/2025. At this juncture, my lord, we pray that direction may be given to the state respondent to dispose of, my lord, the application which has been filed by us.
Yes, who's appearing?
My lord, I'll seek necessary instructions. However, my lord, private respondent, at least in my copy, is not a party, my lord.
Not a party, not made a party, not necessary at this stage also, my lord.
Why not be a party? Anyway. Yes.
It's concerning only the disposal of the application before the respondents, my lord.
21st March 25 this month.
Yes, my lord.
Is this Annexure 8?
Annexure 8.
But I may be allowed to take instructions, my lord, at least in this regard.
Good, Mr. Shangwan, then comes the petitioner. Issue notice. Mr. Kibarachi is present, except on behalf of all the respondents. So no further notice is required. So the prayer of the writ petitioner is the school, correct?
Yes, managing committee.
Managing committee.
School, writ petitioner, bracket managing committee. As a prayer directed against the respondent number 3 for directions to issue. The prayer of the is for directions to direct the respondent number 3 to dispose of an application dated 21/3/2025, wherein the writ petitioner has sought permission, has sought a sanction, or also approval to the minutes of a meeting of the managing committee dated 9/9/2024 to proceed with inquiry proceeding against, what's the name of the teacher?
Badan Boklaksung.
Against one of the teachers, namely Sri Badan Boklang Sun. So it is submitted that in spite of the requests being made as far back to 21st March 2025, when it was received by respondent number 3, any indication to show when it was received?
There is no indication here.
Still no. (15/5/2025).
Where is that?
That is paragraph 14, my lord, page 7.
It's quite off or not? 21/3/2025. Which is stated to be received by the respondent number 3. No response has been forthcoming. Stop. Only that a message has been forwarded with regard to the reconstitution of the managing committee of the school, which has no connection with the application of the writ petitioner. Therefore, it is submitted. It is prayed by the council that the point number 3. No, Mr. Kibi Varathaji, then the council prays him to obtain instructions within 1 week.
Another aspect. Another aspect. The managing committee is there, but who's representing the managing committee? That is not indicated.
Yes. Don't bring up technical objections. Yes, expected within
by
1
its
week.
Get 3.
Yes.
By its Get 3 represented.
Then the GA to obtain specific instructions within 1 week from today. Yes, please, 1 week.
Right.
Item number 5.
This matter, Your Lordship, I pray that this notice may be issued to the party itself, Your Lordship. They fail to give any response to my.
To whom? To you?
Yes, Lordship.
Then how did we engage you in the first place then?
Actually, I would like to withdraw also myself from this case. Actually, no. Yes, Lordship.
Mr. Inoumbri at the outset has submitted that he will have to withdraw himself from representing respondent number 6.
Lordship.
As he has no longer any contact with the said respondent. Stop. What about 1 to 5?
I'm appearing for the district council, Your Lordship.
You file affidavit?
Your Lordship is filed.
Only file?
Your Lordship.
Ms. E. Sutana present behalf from the 1 to 5. You filed the joinder? What are you looking for?
I have to seek instruction from my senior.
Huh?
I have to seek instruction from my senior.
What about the agreement?
That's what, Your Lordship. I have written to them also, but there's no response. I'm completely in the dark, Lordship.
Let notice issue registry to the respondent number 6. Yes.
Highly obliged.
Item number 6.
May it please Your Lordship. Your Lordship, may this matter be called at the end of the board as Mr. Senni is on leg, Your Lordship.
Further?
May this matter be called at the end of the board, Your Lordship. He's on leg, Your Lordship.
7.
Your Lordship.
May it please, Lordship. These are the bunch of contempt matters. Lordship, on the last occasion, submission was made, Lordship, that the respondents were not issuing receipt copies. Thereafter, Lordships, out of the 44 petitioners, 24 have submitted and receipt copy has been issued. But 20 could not submit, Lordship. They were informed that the concerned special officer is on leave. So I would pray, Lordship, kindly have it after 2 weeks. In the meantime,
there's no other person look after it, only one person.
No, he's there now. I think he was on leave.
Perhaps.
Because a special officer has been appointed.
Okay.
So kindly have it after 2 weeks for
No, the only problem here, my lord, because the initial NOC was issued by the same. Of Sora. Now there's an order by this court, my lord, will come to
coming
page.
back to the same.
Yes, it's coming back to
deadlock, Lordship. That
Lordship will just come to page 40 of the writ petition.
Writ petition?
Contempt.
Of the contempt petition, sorry. This was the order passed by this court.
If you recall the order, then what to do?
As the process was taking, yes. So at that point of time, my lord, what happened was that this court has observed that it is not the same of Sora who should issue the NOC. In fact, it's the Sardar of Majai. So now we have informed them also. We said, please give us a copy of the NOC from the Sardar of the village. It appears that they are not being able to get that.
Because the Sardar Lordship is sending us back to the CM. That unless the CM directs, original NOCs were all issued by the CM ship. And the old NOCs we have, but they want fresh ones, Lordship. So it's going back to the same deadlock.
Yes.
And we are being sent back to the CM.
Where is written Majai will give the NOC?
My lord, page 40,
Para 5, Lordship.
para 5. As the process was taking an unreasonably long time, contempt applications alleging non-compliance of the order dated so-and-so were filed by the petitioners. In the course, yes.
Where does this access to?
Yes, because 3A says so, it doesn't say the same. At the time of hearing...
As per the regulation, we have to go as per the law. That means you have to file an application that's not necessary to put CM Sora anymore. That is leveled and...
Lordship, what had happened is they issued a notice saying that since the original NOC was from the CM ship of Sora, please get a fresh NOC from the traditional head. Now we understood, Lordship, that traditional head would no longer mean the CM of Sora in view of this order. So we approached the Dorbarshnam. They said that unless directed by the CM of Sora, they cannot.
The CM of Sora and the Dorbarshnam are...
You call him, CM Sora, then to give directions to Majai to process it. The special officer can do it. Otherwise, again, you have to file an application. Okay, do whatever you have to do. You have an application to file. Yes, this is matters after 3 weeks.
Yes.
So for the orders.
Obliged. This will carry till item 49, Lordship.
50.
Obliged.
Order has been complied with, fully complied with.
Complied, Your Lordship. Your Lordship, a letter has been issued dated 8th May 2025.
Regarding which?
Regarding the regularization of that.
Okay. Yeah, Ashish Rai, please, Lordship.
Your Lordship, if I may submit, Your Lordship, the letter was dated 8th May 2025, appointing the petitioner herein in permanent capacity, Your Lordship. But Your Lordship, this letter till date, as per my instructions, has not been processed yet, Your Lordship. So if this matter can be closed with the direction to the
It has been
respondents.
fully complied and petitioner was informed.
How can we offer orders there?
Your Lordship.
Yes.
Maybe close to it, Lordship.
Ashish Rai, Senate Counsel for the respondents has referred to affidavit file indicating compliance by order dated 8 May 2025. Stop. Court refuses the same. Accordingly, the order being since been complied, the matter is disposed of. Close, contempt, close and dispose of.
Obliged, Your Lordship.
Contempt and register. Please, Lordship.
51.
Lord, we have taken steps as against respondent number 4, my lord, on the last date.
You're appearing on number 4. Who's appearing number 4?
No, they are supposed to take steps, Lordship.
We have taken steps, my lord, already.
Okay.
So the directions of fresh steps.
They had appeared earlier.
In the case the ED card that you received from respondent number 4, just after 2 weeks for service report.
No.
Yeah.
52.
Well, I appear for the respondents and seek some time.
You filed affidavit?
No, I couldn't file.
Why?
This is another one. My officer is out of station. He is for some officer.
Lordship, respondent 7 is yet to enter appearance.
He will be returning after third week. So maybe.
We don't know about that.
Because
1267?
7 is yet to enter appearance, Your Lordship.
Who's 7? By name?
Yes.
Yes, Your Lordship.
Who's number 7? Is your officer only?
No, yes, teacher.
7 is Rajendra Trivedi. He's been served.
Yes, Your Lordship. I've also filed the affidavit of service, Your Lordship, on last date.
Yes, Mr. M. was on behalf of the respondents 1 to 6. Please allow further 3 weeks' time
Hello.
to file affidavit. Please allow. Stop. MSG Sage Marbo. Then Council has also submitted that in spite of service of notice on fund number 7, no appearance has yet been made on his behalf. The same is noted is next paragraph lists the matter after 2 weeks or 3 weeks. So expected the respondent 7 shall make appearance on the next date.
After 23.
3 weeks.
Yeah, maybe after 20 days he will return to, he will get it signed.
Yes, okay.
53.
That is, you know how to handle it. Yes.
Much of this.
You see this matter, Lordship, is this again because based on that order signed only by one member, Lordship.
Yes,
May I please, Lordship? Lordship, I humbly submit that our prayer in the second part of this writ petition be also considered, Your Lordship, as this impugned order suffered from more than irregularities, Your Lordship.
yes. The order motion 31, that is 31, no? As has been noted in the other orders of the Executive Committee that have come before this court, which have been signed by only one member and were remanded, that this instant matter also suffers from the same defect or non-compliance of rules also of the Constitutional Council rules and others. Accordingly, the impugned order 4th December 2024 is set aside and the matter remanded back to the Executive Committee, KGDC, for rehearing afresh by the for rehearing afresh. That the matter shall be disposed of expeditiously.
Next item also same order.
55.
May it please Your Lordship. Your Lordship, we've not received specific instructions, Your Lordship. Therefore, I'm praying for some more time.
You've not got any information?
My Lord, from our side, we have not received, my Lord.
When?
Now,
1 week?
1 week, Lordship.
Is 1 week for them allowed to the Embassy by Dr. Musica to find affidavit to apprise this court as a communication to the petitioner about the setting aside of the summary.
Summary.
Of setting aside of summary Assam
Rifle Court
proceedings.
Highly Lordship.
56.
My lords, I pray for the week's time, my lord, to file our rejoinder.
How many times you prayed?
This is the second time, my lords.
Yes, I prayed for the 2 weeks times allowed for rejoinder. Just thereafter.
Highly obliged.
57.
Where's the respondent? Yes, Barasaji is still sitting there.
Sorry.
Dreaming or something. Yes.
Your Lordship, I need some more time for filing affidavit.
What's the matter about?
It's
This is the land acquisition
land
matter.
acquisition matter, Your Lordship.
Where's Mr. Counsel? Where's Mr. Deb? He was here just now.
Yeah, they had appeared on the last date, my lord.
I received a voice comment, Your Lordship. I need some more time.
Where's for number 6? Number 6, right?
Number 5, ma'am.
Number 5. Yes, MS Abdulsaji, we have 1 to 4 praise for the 2 weeks' time. None appears, we have for number 5.
58.
Okay, let's pass order. 58. Let me Mr. M. Ahmed Innocent Counsel so and so submits that as the respondent.
2, 3,
this
4.
Is 2, 3, and 4 are just a branch of the parent called India Limited. Notice may be issued to the said respondent. Stop. Inconsistent submission thereof. That notice issued to 2, 3, and 4. Stop. Within 3 days, interim order to continue till next day.
59.
Steps have been taken, Your Lordship.
Yes?
Steps have been taken.
I'm entering appearance on behalf of respondent number 3, Your Lordship.
1 second. One and two, we re-examined it.
Yes, my lord. Hearing has been taken up on 29.
Then?
Now we are passing the order, lordship.
Mr. R. Kharsat, then counsel appearing for respondents on 1 and 2. Oh, no, first, note down, Mr. R. K. Syndrome. And you are for?
I'm appearing for the respondent number 5.
Has an appearance to have respondent number?
5, Your Lordship.
No.
Respondent number 3, Lordship.
Number 3. And MS EDCM for 4 and 5.
Only for 5.
For 5. Yeah, for 4. Yes, for 4. That's for 4 and for 5. Stop. Mr. Arka, next one, Mr. Arka's Learned Counsel respondent 1 and 2 has submitted that the matter concerning the election of Sardas Narat tendering has since been taken, had been taken up on 29/5/2025 by the respondents 1 and 2,
and now they
will
are
soon be published.
Yes, except for publishing the order.
We have made certain submission before the EC to be.
And the order will be delivered soon. Yes, it's after 2 weeks.
Much obliged.
Hearing 62.
May I please, Your Lordship? Lordship, I'm seeking. Lordship, I'm praying for some accommodation.
The other petitions are interested.
Lordship.
Very much.
Lordship.
The general is not here also. List after 2 weeks.
Highly obliged, Lordship.
Yeah, the competition.
65.
Lordship, even in this matter, Lordship. Lordship may have this after a week's time. Lordship will come prepared, Lordship.
Lordship would only like to do fresh matters. Don't like eating stale food, right? Yes.
No, Lordship.
That you nodded, that means yes. We'll record that in the order.
Lordship.
Right, MSK D. Cruz has submitted that we don't like doing, or the council don't like doing old stale matters. We prefer doing fresh matters. That's correct.
No, Lordship.
Then, every time adjourning this matter will take course soon. That's after 2 weeks.
Highly obliged, Lordship.
I will record that in the next order.
Lordship.
67.
Yes.
Please, Lordship. Lordship, step has been taken, Lordship, with regard to the last order. We have served copy to respondent number 5, Lordship.
Lordship will seek instruction whether they will file the affidavit on behalf of respondent number 5.
5 is whom?
Is a joint secretary
of
THEDC.
You just received copy.
He has received copy.
After the court, this last order communicates on a copy to patient number 5. Yes, Mr. Arkas was present behalf number 5. Yes, for how much time?
2 weeks time.
You have to file affidavit. This thereafter. Yeah.
70.
Yes, Mr. Chanda. Yes.
This is again that matter, my lord, where I'm working as I'm working as in a ministerial post in litigant college, my lord. There was some.
What happened? He suspended again. What's the current status now of the case?
They have proposed to initiate a fresh inquiry as against me again,
Right.
despite the order passed by this honorable court on an earlier occasion, holding that if at all, my lord, we had challenged the inquiry report earlier, issued by them earlier, my lord. That your lordship said that if any order is to be passed based on that inquiry, you pass an order.
Yes.
Now they realize that, my lord, their inquiry is a futile exercise, and nothing much could be done on the basis of that inquiry report, my lord. They left that inquiry report where it was, and they proposed to issue initiate a fresh departmental inquiry, my lord. Against that, we are before your lordship.
You are appearing for litigant.
Your Lordship.
Yes.
Respondent 3, 4, and 5, Your Lordship.
Yes.
Your Lordship. Mr. Sen he's on leg, Your Lordship.
What to do? We'll wait for him. Substance allowance you're getting?
He got something, Millets. That's after some orders fell from my lords. Something came.
You've always been paying, Your Lordship. Always
You're
been.
that
for
is-
litigant?
No, I'm for the government, Your Lordship. The subsistence allowance was being paid
Okay.
to the government regularly.
See, the direction was that he's not, Mr. Sen's not here. What am I saying? We need to, after 1 week.
If your lordships kindly please, my lords, we can have it sometime later part of this week, subject to my lord's convenience.
I don't know. Or even all lawyers have difficulties. This court has no difficulty to take a remand.
Next week, otherwise.
When? Well, after 1 week. Let it come in the regular list again.
Let it. This is otherwise retired, my lords. That's what I'm told.
You're supposed to have retired in May.
No, the direction is very clear. Just what I just saw the last order, that you complete the inquiry as per that inquiry 2006. You exonerate, finish.
Well, it's because that report came, and in that report, my lords, he's given a clean sheet.
Yes.
Now,
So
after that,
you can't now start,
Fresh inquiry.
how will you de novo inquiry again?
and this would be a never-ending exercise, my lord.
Second call, item number 6.
All right.
16. Information hearing. Yes.
Lordship.
Lordship, on last occasion, they
You
raised.
said that it can be into 2 parts, the order.
Yes, Lordship.
So one
The
part is
composite-
appealable, one part is not.
Lordship,
So you
the-
got authorities.
Lordship,
Very good.
specifically on this issue raised by. Specifically on this issue, it is raised in.
You give them a citation. You have a look at it, and you have it tomorrow.
Yes, Lordship. Tomorrow,
Tomorrow.
Lordship. Okay, Lordship, tomorrow.
Or you're not free.
No, Lordship. Tomorrow is.
Okay, we'll have it day after tomorrow then. Yes.
No, Lordship. Wednesday I have Nongpo matters. Tomorrow is okay, Lordship. Nongpo actually.
Tomorrow.
Yes, Your Lordship.
Don't mention Nongpo matters thing.
Lordship.
This is the first court in the state. You saw Supreme Court was said recently.
Lordship.
What did that Supreme Court judge say? He said that judges have very frail egos.
Your
Big
Lordship.
inflated egos. So if you say lower court has no precedence than the higher court, they will
Lord-
take it.
Lordship.
They'll take it adversely.
Lordship, I apologize, but.
Yes, the judgment has been produced by MSP Bhattacharya today in support of the case. You give her a copy. Yes. MS Ibla is now sometime examined the same. This is on Thursday.
Your Lordship, may the interim order continue.
Interim order continues. Thursday you come.
Yes, Your
Give
Lordship.
this and that thing. But tomorrow again they'll have problems. Only yesterday you have not had time to see. Yes.
Obliged, Your Lordship.